Reserved powers? Seriously? Why are we wasting our time watching a video about a doctrine that has been rejected by the High Court of Australia? The idea of the reserved powers has been casted out in the engineers case back in 1920, Renato. It has failed. It's obliterated. It has even been called a heresy. A heresy. But is it really? What does it actually mean? Hello everyone, my name is Renato Costa. This is Aussie Law, and today we will talk about sections 106, 107 and 108 of the Commonwealth of Australia Constitution and the doctrine of reserved powers. You see, one of the presuppositions of living in a federal country is that political power is shared. No tier or level of government holds absolute power. Political sovereignty exists in the Commonwealth, but is divided between the Commonwealth and the states. In Australia, this means that certain powers are conferred by the Australian Constitution to the Commonwealth, the federal level, and some powers remain with the scope and jurisdiction of the former colonies, now the states. And so this is the idea behind the states' reserved powers, that the states have control over their domestic affairs without federal interference. That is, there is a body of legislative powers that have been reserved to the states into which federal legislative powers cannot extend. Now, how can we say that such a thing as the reserved powers existed in the first place? Let's start with section 106. It says that the constitution of each state of the Commonwealth shall, subject to this constitution, continue as at the establishment of the Commonwealth, or as at the admission or establishment of the state, as the case may be, until altered in accordance with the constitution of the state. When the Commonwealth of Australia was created by the Constitution, the colonies already existed, and more, they had their own laws and their own constitutions. So section 106 basically allows the state constitutions to continue existing with the caveat that they are now subjected to the constitutional structures and powers established by the newly enacted Commonwealth Constitution. As Quick and Garen commented, the states retain their constitutions, the parliament, the executive and judicial organizations, subject only to the loss of those powers which, by the federal constitution, are withdrawn from the scope and operation of state constitutions and brought within the sphere of the federal constitution. In Briverton and Goldman from 1988, Justice Brennan was of the view that section 106 preserved the mutual independence of the states. In Ray Tracy ex parte Ryan, Justices Brennan and Toohey declared that the state courts are an essential branch of the government of a state, and the continuance of state constitutions by section 106 of the Constitution precludes a law of the Commonwealth from prohibiting state courts from exercising their functions. So, in summary, the section provides that the state's constitutions, and particularly here with respect to the structure of the legislature, the executive and the judiciary, they remain unimpaired and intact after the federation, even though certain powers were removed from the states to the Commonwealth. You know, one aspect that deserves attention here is the fact that the executive of the states remains constant. This means that there is a direct communication between the states and the Crown that needs not be intermediated by the Commonwealth. And this dynamic was established during the colonization period and remained unchanged for a long time, even after the enactment of the Federal Constitution. But in my next video, we will talk about the relationship of the states and the Crown according to the Colonial Laws Validity Act and the Australia Acts of 1986, which changed this dynamic a bit. If you do not want to miss that video, then make sure you are subscribed to our channel and that you've hit the bell icon as well, so you're notified every time I upload a new video. Well, and since we're at it, why don't you click the like button in this video as well? Section 107 is crucial for the interpretation of reserved powers doctrine. It talks about the saving of power of state parliaments. The section says, every power of the parliament of a colony which has become or becomes a state shall, unless it is by this constitution exclusively vested in the Parliament of the Commonwealth or withdrawn from the Parliament of the state, continue as at the establishment of the Commonwealth or as at the admission or establishment of the state, as the case may be. This provision is essential to keep the federal balance. The powers of the states were maintained with the exception to those powers that were now given to the Commonwealth. You see, the states had plenary powers before federation. However, with the enactment of the Constitution and the creation of the federal level, some of these powers were transmitted to the Commonwealth along with new powers that had to be created for the operation of the federal system. But overall, the powers of the states should continue to the largest extent possible, unaffected and intact. And this was the idea since the beginning. As we can see expressed by Henry Parkes during the Constitutional Convention in Sydney in 1891, it is in the highest degree desirable that we should satisfy the mind of each of the colonies that we have no intention to cripple their powers, to invade their rights, to diminish their authority, except so far as it is absolutely necessary in view of the great end to be accomplished, which, in point of fact, will not be material as diminishing the powers and privileges and rights of the existing colonies. So, in the early case of Iron Barger from 1906, the original composition of the High Court of Australia, called Griffith's Court, stated the following: the scheme of the Australian Constitution, like that of the United States of America, is to confer certain definite powers upon the Commonwealth, and to reserve to the states, whose powers before the establishment of the Commonwealth were plenary, all powers not expressly conferred upon the Commonwealth. This is expressed by Section 107 of the Constitution. With the Federation, some powers do not belong to the states anymore. These include the exclusive powers of the Commonwealth in Section 52, the power to make laws with respect to duties and customs and excise in Section 90, the coinage of money in Section 115, and the power to raise and maintain military forces in Section 114. In fact, even some powers in Section 51 are not within the scope of the states anymore, like, for example, the naturalization power in subsection 19. Generally, the states still have power over some important areas such as agriculture and forests, education, health, land, mining and policing. But of course, with the creation of the Commonwealth, the states lost some of its powers and some powers needed to be granted to the federal level. All in all, and based on this view of the history of the Federation, as well as a prudential interpretation of Section 107, the reserved powers doctrine rested on a conception of the Australian Constitution in which it received its political legitimacy and essential federal structure from a federating compact negotiated between elected representatives of the federal constituent states and ratified by their respective voters. Section 108 says that every law in force in a colony which has become or becomes a state and relating to any matter within the powers of the Parliament of the Commonwealth shall, subject to this Constitution, continue in force in the state. And until provision is made in that behalf by the Parliament of the Commonwealth, the Parliament of the state shall have such powers of alteration and of repeal in respect of any such law as the Parliament of the colony had until the colony became a state. According to Justice Isaacs in Commonwealth and New South Wales from 1923, this section was designed to avoid a complete state of anarchy after the Federation. The idea was to say that the laws of the states would continue until the Parliament of the Commonwealth legislated with respect to those same subject matters, just to keep some stability going in the early days of the Federation. In R. and Bamford from 1901, Justice Owens of the New South Wales Supreme Court summarized this section in the following way: the existing laws of the state are to continue in force, even though they relate to matters within the exclusive powers of the Parliament of the Commonwealth, until that Parliament enacts laws relating to such matters. So, when it comes to the doctrine of reserved powers of the state, these three sections give us constitutional support to say that, considering the federal system and the dynamics of powers between the two levels of government, the states retained some powers after federation. That is, some powers were reserved to the states only, and the Commonwealth could not interfere with them. However, because you've watched our video about the engineer's case, you know that this doctrine has been rejected. As Nicholas Arounian has said, the old reserved powers doctrine offered a way in which the impact on the remaining powers of the states could be taken into consideration when interpreting Commonwealth powers and characterizing Commonwealth laws. In the engineer's case, however, the reserved powers doctrine was decisively rejected, and a new approach to the interpretation of the Constitution was inaugurated, under which it became illegitimate to seek to maintain some kind of appropriate balance between the powers of the Commonwealth and the states. So, in the payroll tax case, for example, the doctrine of reserved powers was called a heresy. Justice Windeyer said that an interpretation of the Constitution that returned to the doctrine of reserved powers would be the adoption of a heresy. He had already said something similar in the Marriage Act case from 1962. In fact, some judges called this doctrine a ghost during the proceedings in the work choices case. But is it though? Professor Arounian has argued, for example, that the reserved powers doctrine has many versions that can still be seen around today. I'll link his paper to the description of this video so you can read it later. So look, even though the High Court seems hesitant to acknowledge that the doctrine exists and is alive and is indeed a necessary one, we can still see it around today expressed in one version or another. In the recent case of Spence and Queensland from 2019, for example, the majority of the High Court rejected an attempt by the Commonwealth to restrict the operation of state laws that concern certain electoral matters. And in their judgment, the majority composed of Chief Justice Kiefel with Justice Bell, Gagler and Keane said that the federal law includes activities the regulation of which is within the heartland of state legislative power. The heartland of state legislative power. Because Australia is a federation, and because sections 106 to 108 safeguard the continuity of the Constitution's powers and laws of the states have certain powers reserved. That is, there is a heartland of states' powers that cannot be interfered with by the Commonwealth. Based on sections 106, 107 and 108 of the Constitution, it seems to me that the doctrine of reserved powers is not really a heresy. Quite the contrary, it is a sound constitutional doctrine, one that maintains a necessary balance in the federal system. Of course, the engineer's case brought about other consequences to the federal dynamics. In the playlist here on the side, you can see some other cases that led to the imbalance between the Commonwealth and the states that we see in our federal system today. Why don't you take some time to watch them now, and I'll see you there.